So you're on to me, but I'm marking you in the dissent in this case when I do.
This is the sitting in on the witness expert sitting.
Oh, this is the Chaucer, yeah.
Yeah. Are we ready for Mr. Jonchuck? Thank you.
I mean, hard. Yes. That is what you want.
Sure.
That'll be for the next one.
So now,
Yes, please.
okay.
Yes.
You got it.
Maybe like 15.
Oh, yeah, I know. I need to see that, you know, or we can take care of this, you guys. Maybe up there. Actually, something comes up. I'm sure it's easy. Bill.
Morning, Mr. Jonchuck.
Good morning, Mr. Jonchuck.
Your Honor, I think our co-counsel is trying to deal with some victim witness issues because they were obviously gone by the time we were out of court yesterday, so we're working on
Okay.
coordinating things.
Just make sure you check your cell phones, electronic devices, make sure they're off and put away.
Okay, are you ready to discuss the issue about the state's mental health expert sitting in the trial goes on?
Yes, sir.
Okay, Mr. Ellis, I haven't read all of them, I've skimmed through. The first one and then the Hernandez case.
Mm-hmm.
Come on.
Judge, under 90.616, subsection 2C, that's the exclusion of witnesses. The court can order sequestration except where a witness may not be excluded if their presence is essential to presentation of the party's cause. And under 90.704, facts or data upon which an expert bases an opinion or inference may be perceived by or made known to the expert at trial or before trial. And I have 4 cases to cite. The first one would be Hilton. That's 117 Southern 3rd, 742 from March of 2013. It's a Florida Supreme Court case. Basically, sequestration, as the court's well aware, is to prevent coloring of witnesses' testimony. Well, experts rely on other witnesses' testimony to help form their opinions. In that case, the state expert was allowed to sit through the penalty phase of the murder and give notes to state attorneys and assistant state attorneys, and the court, Supreme Court found that the court did not abuse its discretion in allowing this.
Can I just ask you some questions about that case? It's under footnote 9, it talks about the state was late filing its notice of intent to seek the death penalty, which prevented the expert from examining the defendant. I don't think that's true in this case, is it?
No, Judge.
Okay, and it was necessary for the expert to be excluded to give him a chance to provide meaningful assistance to the state, which I guess he couldn't do because the death penalty notice was late. And in other words, your experts have had plenty of time, correct, to do whatever they were going to do?
Yes, Judge.
Okay. Witness sequestration rule allows an exception when a witness's presence is shown by the party's attorney to be essential to the presentation of the party's cause. How would you respond to the fact that the presence is essential?
Several different issues, Judge. As if the defendant testifies, I think that would be essential for the state. There's a case that we have that would say that that would make it essential for the experts to provide us information regarding cross-examination of the defendant and their evaluation of the defendant. Also, I think they are essential when the other experts testify to help provide us information in areas of cross and evaluating the testimony of the experts. As to the civilians, I think that is a situation, Judge, where the experts are allowed to testify as to what occurs at trial. I'm not sure it's quite as essential as it would be for an expert, except for Attorney Torres, who was slightly before trial. They waived her attorney-client privilege, and our experts have not had the opportunity to read in depositions of her or have contact with her. So we would ask that that would be an essential situation too. So we believe that the defendant testifies is essential, Torres is essential, their experts are essential, and I believe that the court, within its discretion, could allow the experts to sit through the testimony of the civilian witnesses called in after the first part of this trial, the state's factual part of the case.
Okay, so let's go on. Were you going to go through any other cases?
Yes, Judge, briefly. On Hernandez, that was another case where the state's expert in the penalty phase was allowed to testify, not to rebut factual witnesses, but to assist the state and to testify regarding issues for the state at that point. And that, Hernandez is 4 Southern 3rd, 642, Supreme Court case from 2009. There's the Knight case, 746 Southern 2nd, 423 from 1998. That is also a Supreme Court case. In that case, the detective was allowed to sit through an entire resentencing. The court indicated that the purpose of sequestration is to prevent or discourage fabrication, inaccuracy, or collusion, and to avoid coloring the testimony. Having the state's experts sit through the testimony of these witnesses would not be a situation where we would have fabrication, inaccuracy, or collusion, or coloring their testimony, which is the whole reason for sequestration. In that case, the officer was allowed to testify because it was a couple of decades had passed since the original case, and he was allowed to testify regarding resentencing and subject to cross-examination. And last was Strausser, S-T-R-A-U-S-S-E-R, 682 Southern 2nd, 539, a Supreme Court case from October of 1996. And that is a court-appointed doctor was allowed to sit through the defendant's testimony at trial. They considered that not an abuse of discretion. So that's why I brought up the defendant testifying. If he doesn't, our experts should be allowed to be there and be present for that. Even though they've had a chance to interview him, I believe it would be important for them to do so. So I would think it's essential for the Torres, the defendant, and the experts, and I think it would be within the court's discretion to allow for the rest of the witnesses. And the reason rules for sequestration really wouldn't apply when they're like it's normal witnesses, because that's what experts do. They rely on the testimony of others.
Okay, and I'm looking at the Hernandez case, and I'm on head note 23 on the top of page 4.
Yes.
And it says, only experts' professional opinions differed from those of defense witnesses, and there was no suggestion that either his opinion or his factual predicates upon which these opinions were based would have been different if he had not been allowed direct access to other testimony elicited during penalty phase. If I'm not mistaken, yesterday you said at the bench that one of the reasons for doing this was to see if an expert's opinion was different after listening to these witnesses, right?
So that could occur, yes, Judge. In that case, it says that in that particular case, there was no suggestion that his opinions had changed. It doesn't say that it can't be done so his opinions don't change or won't change. It just said in that particular case, his opinions didn't change. That's what, if you look on page 19 of the handout. He did not refute, it says, in sum, Dr. McLaren did not refute the factual testimony of the witnesses during the penalty phase and admitted that he observed the testimony of other witnesses during the penalty phase. Only his professional opinion differed from those of the defense expert witnesses. Further, there's no suggestion that either his opinion or the factual predicates upon which those opinions were based would have been different if he had not been allowed direct access to the other testimony elicited during the penalty phase.
Yeah, but in this case, that's part of the consideration that you are considering and asking me to do that, right?
Well, it could occur. I think we have to take that that is something that could occur, yes.
But that's part of the reason for you wanting to do this.
Yes, Judge, and to, again, with the essential as witnesses to provide us information, and obviously we're not trained in psychiatry and psychology, and I think that we are allowed to have those experts assist us in their cross-examination of those witnesses, and the defendant and Torres, and then we're asking for use of court's discretion for the other witnesses, and also, Judge, this applies to the defense. This is not a one-way street. They're experts who do the same thing.
Well, they haven't asked me to do that.
But if you ruled, it would obviously allow them to do it.
Yeah, obviously.
Right. And I know they haven't asked for it, but I'm not asking for something that is only one-sided.
Well, I think it is, because you're the only one asking for it.
Well, if they chose not to do it, that's a decision they made.
The burden is on you, though, because you're asking me to do it. Isn't that correct?
Correct. I believe we presented why we believe that they are essential, and those witnesses we think they're essential to, and why we're asking you to use your discretion on the other witnesses.
Well, this last one, Strausser, is the defendant. Okay, this is, and whoever from the defense wants to address this.
Yes, Your Honor.
Okay.
I think several of the questions that the court had for Mr. Ellis are really what I would like to argue, but I think it's important to go back and look at what the purpose of the sequestration rule was at common law. And the cases that I have for the court are the same ones provided by the state. I mean, they're the same thing. So in looking at the Hernandez case from the Florida Supreme Court in 2009, in referencing a U.S. Supreme Court case from 1976, they talk about the dual purpose of the rule of sequestration, that being that the rule exercises a restraint on the witnesses from tailoring their testimony to that of earlier witnesses, and the rule of sequestration aids in detecting testimony that is less than candid. The Florida Supreme Court also talked about the purpose of the rule of sequestration in 1998. This is also cited in the Hernandez case, when they say the purpose is to avoid a witness coloring his or her testimony by hearing the testimony of another, thereby discouraging fabrication, inaccuracy, and collusion. At common law, as we know, making an exception to the rule of sequestration was discretionary with the court. The Hernandez case talks about Burns v. State, which is at 609 Southern 2nd, 600, Florida Supreme Court from 1992. And in that case, it was found to not be an abuse of discretion for the state expert to be present during the entire penalty phase of a capital trial, including the fact witnesses, when the defendant had not been required to submit to an examination by the state's expert. And sitting in on the testimony was the only avenue available for the state's expert to then be able to offer meaningful expert testimony and to rebut the defense's mental mitigation evidence. That is certainly contrasted from the situation we have here, where the state has had access to Mr. Jonchuck for multiple days of evaluations by their experts. They've had access to all of the records, all of the depositions, all of the collateral sources. So this is absolutely not a situation as existed in Burns, where the only way for the state to rebut the evidence is to have their experts sit in. Of course, the rule of sequestration was codified in 1990 and made the sequestration be, when it was discretionary at common law, the rule made it demandable by a party when it was codified. At the request of the party, the court shall order the witnesses excluded, of course subject to the exception that we are talking about. The exception being if the presence of the expert is essential to the presentation of the state's case. And I would like to respond to a couple of the state's arguments on that. Of course, the burden is on the state to prove that the breaking the rule of sequestration is essential to their case. They talked about if Mr. Jonchuck testifies that they should be allowed to sit in. I would say that would be a bridge to cross if and when we get there. When other experts testify, of course, we know that that is commonly an exception to sit in on the other experts. As to the other civilian witnesses, the state and their experts have had access to all of the witnesses since the beginning of 2015. They have done interviews, collateral interviews. They have had access to the deposition transcripts and all the reports, and could call and find out what these people have to say at any time. The state did argue yesterday and said here again this morning, well, what if a witness says something that is different and it changes the opinion? I think that that's a matter to be handled on cross-examination. A trial is not supposed to be where we're finding out in the middle of trial, both sides, that an expert is changing their opinion. If something changes in an expert's opinion under Rule of Criminal Procedure 3.220, the state has to put us on notice of that. They have to tell us that. It is not to be trial by ambush where we're finding this out in the middle of testimony. So they've had access to all of the witnesses. The state specifically spoke about witness Genevieve Torres and argued that it is only just before trial that they have the privileges waived, and so they had access to her, and that is just not accurate. The state had access to her at Invest and was able to interview her, and I believe did interview her. I don't believe, they did interview her. The privilege was not waived just before trial. We filed notice of the attorney's records or file in September of last year, which I believe, if my count is right, was some 7 months ago. So this is not a surprise that we've just now waived privilege and that they somehow need access to the information. She's been available, privilege has been waived for months. So we're not doing something to surprise them at the last second. The case that the state cited of Strasser, which is also talked about in the Hernandez case, is in contrast, factually, from our situation. That arose only when, well, at this point, as I said, if Mr. Jonchuck decides to testify, I think that's something that could be addressed if we ever need to get to that point. But that's what the Strasser case was about. In that case, the Supreme Court ruled that it was not an abuse of discretion to make the exception to the rule and allow the expert to sit in when it was the insanity defense and the defendant testified. And the expert was only allowed to sit in for direct examination. So we're not anywhere close to where we need to be to come to the factual circumstances of Strasser at this point. So I would suggest that although an abuse of discretion was not found in that case is very much distinguishable. And I won't belabor the point of Hilton v. State because the court pointed out in that case the exception was made because of the state's late notice of the filing of the notice of intent to seek the death penalty under the rules that govern that. The state's expert was not allowed to examine the defendant, and so the only way to rebut that testimony presented by the defense was to make the exception and break the rule of sequestration. Again, that is distinguishable from our case completely because they've had all the access to Mr. Jonchuck over the last 2 years and have done all their interviews and evaluations. So at the conclusion of Hernandez, what we have, and I wanted to distinguish the Knight case that the state brought up. I mean, this is again a very factually different scenario than what we have here. In this case, the detective who was allowed to sit in through the course of the proceedings, this is under headnotes 4 and 5, the detective was a fact witness and he was testifying as to what others had testified to 2 decades earlier, or as to what they had said in the sworn statements. He was therefore, in a sense, a reporter of what other individuals had long since said under oath in a recorded statement, and his testimony was subject to being carefully checked by comparison to the transcripts of the trial testimony. So, completely different factual scenario. The detective was there to read into the record and testify as to the previous statements, not to listen in and look for inconsistencies in testimony by lay witnesses and then be able to change an opinion or do whatever else they might do upon hearing that information. So I would suggest that Knight is completely not on point and should not be regarded. Going back to Hernandez, the court said in assessing the error in allowing the expert to stand in, it was not prejudicial because the state expert did not refute any of the factual allegations of the lay witnesses, which the state has already said they might want to do. The expert did not dispute the defendant's history, of substance abuse, and the state's expert testimony correlated with the other experts regarding diagnosis and other things. That was not in dispute, and as we know in this case, that is in dispute. The expert in Hernandez was not basing his opinions on other experts' opinions, and the only difference that he was testifying to in that case was the absence, in his opinion, of the statutory mitigators, whereas defense experts said statutory mitigators exist. What we learned from Hernandez is that faced with or provided the same information, the state's expert simply said, no, I don't think they do exist. So it wasn't a factual dispute, it was an opinion dispute, which is what we have here. So the state has repeatedly said that they're asking for this so that the experts can listen for factual differences and adjust their opinion accordingly. And I would suggest that none of the case law presented gives the court authority for that situation. In fact, any time that we have seen in these cases the state expert be allowed to sit in without an abuse of discretion is an entirely different factual situation than we have here. So we would ask that they not be allowed to sit in for the lay witness testimony.
Okay, Mr. Ellis, do you agree that the attorney-client privilege with Attorney Torres was waived September 2018?
No, Judge.
Okay.
And that was part of the problem. Even Attorney Torres didn't believe that. She wasn't, when we interviewed her originally, we were not allowed to go into a lot of what was said because she brought her attorney with her and then she claimed attorney-client privilege. She was still claiming that even though when she relieved reveal the client file. She was waiting for the defense to formally file a written waiver. They never did so. It wasn't until very recently that we were able to go talk to her at her office that she finally felt that that was enough of a waiver. But she was still, in her mind, asserting the privilege until just very recently, because the defense never filed a written waiver of the attorney-client privilege. So I disagree that it occurred in September. They did reveal their file, but according to Ms. Torres, that was a gray area in her opinion, and she did not feel that it was sufficient to grant us the ability to talk to her.
Okay, well, so how, was there ever a written waiver of attorney-client privilege?
Not that I'm aware of.
And then how did, when you say, when did you finally talk to her? Did you depose her or just talk to her?
It was a couple weeks ago, Your Honor.
A couple of weeks ago?
Yes, we went to her office and we said, can we talk to you about this case? And she goes, well, at this point, I feel that we've reached that level that it is a waiver. So she made a decision at that point to allow us to talk to her about what occurred during the attorney-client meeting.
Do you know why she came to that opinion, that suddenly it was waived when it wasn't before?
Well, I can also add that I spoke with the defense, and they agreed, as we were discussing some pretrial issues just before the trial began, that was a waiver, but that was a recent conversation with the defense. And so that was also something that we discussed with Ms. Torres, that they believe that there has been a waiver.
Did you take a depo or just talk to her?
Just talk to her.
Okay, and did you supply the essence of that conversation to your mental health experts?
No, Judge, we haven't had that opportunity because we didn't have anything in writing or recorded or anything provided. We did not do that.
Okay. Do you disagree with anything Mr. Ellis has said about the availability of the waiver?
Well, we believe it was waived in September. I can't control what Ms. Torres's mind is, but we disclosed the entire file in September. Why, and if her position, Ms. Torres's position, or the state's position is that we were waiting for them to file something that said it was waived, like I guess that they're saying a piece of paper signed by Mr. Jonchuck.
Right.
We've never filed one, so without that being filed, she felt free to talk to the state and disclose everything 2 weeks ago, so I don't know what's changed. It was waived when it was waived when we disclosed the file.
Well, I guess I'm trying to figure out what initiated the visit to her a couple of weeks ago. I mean, I understand why you're under the understanding that it's not waived, there's no, and why she's saying that too, but then that's what I don't get.
Well, Mr. Boland spoke with the defense. They indicated that was considered a waiver by them. We told her of that, and then she felt more comfortable in considering that a waiver as well.
Okay.
That's all I can tell the court.
All right, but
she was the one making those legal decisions. We had to allow.
Right, obviously. So after you got the file in September, her position was still, that's not a waiver.
She felt it was gray area and didn't feel comfortable as being a full waiver, correct?
Okay, and somebody contacted her from the state after that and said, okay, we're ready to depose you or whatever, and she said, not so much.
Correct, we want to come talk to you. This is what the defense has told us, and we went and talked to her a couple weeks ago.
Okay, so pursuant to this, I am going to deny the state's motion to have their experts present during any testimony except that of Attorney Flores, and if the defendant Torres, if the defendant testifies as Ms. O'Neill says, we'll deal with it then. When you look at her, I understand that it's discretionary. However, when you look at these cases, I don't see anything that is similar to what you're asking me to do. And when you look at Hernandez, that's the case where the opinion of the expert did not change. However, in this case, I believe part of the state's goal is to see if one of their experts' testimony would change based upon what is said in the courtroom, which is, I think, different than the spirit behind Hernandez. When you look at Strausser, that's really clear. We've talked about that at nauseam. And that was just the expert being present in the courtroom while the defendant testified. So that's not what we have here. Knight is the detective in the resentencing, which he's basically a fact witness looking at the prior testimony. That's really different than what we have here. And we have Hilton v. State, 117 Southern 3rd, 742, and that's where there was a late notice for the death penalty, and the only way the state could have access to the medical experts and the defendant, said from exam, was to be in the courtroom, apparently where the expert listened to the defendant. So it seems to be most of these cases talk about some late development where the state's expert was unable to get the information from a witness and had to sit in the courtroom. And nobody has suggested that's the case here, other than Attorney Torres's testimony and perhaps the defendant. And additionally, and this is not why I'm ruling this way, it would raise another issue that would increase the length of the trial, and that is, if the expert's testimony changed, then the defense probably would be entitled to do an entire new deposition. But it's not why I'm making the decision, but that would also be a drawback of the decision. So the state can have their experts sit in for Torres and the defendant.
Not other experts, just because of...
Oh, the other expert, for sure.
Oh, you didn't say that, that's why I
Oh,
wanted to
yeah,
clear that
that's
up.
a given.
Okay, well, I didn't take anything as a given, so I wanted to make sure.
That's a given. Okay, are we ready to start?
Yes, Judge.
Okay, let's bring in the jury, please.
Can we approach real quick, Judge?
Sure.
As soon as you get in line, bring them in.
No, hold on just a minute. I gotta ask Mr. Jonchuck about this stipulation. Okay? Mr. Jonchuck, you don't have to stand up, sir. However, I need to ask you about this stipulation, okay? Your lawyers and the state have stipulated that the medical examiner can testify that the dead person is Phoebe Jonchuck, your daughter. Without that stipulation, they would have to present a witness who would have to identify her as, that would have identified her as Phoebe Jonchuck, or somebody, I guess now, that could theoretically identify her. So in skipping that, everyone is stipulating to that. Do you agree with that? Do you understand what I said?
Yeah.
Do you agree? Jonchuck. Let's bring him in, please.
Deputy Rex, you can bring him on. You can bring him in. Jury's in the jury box and is seated.
Thank you. Good morning, ladies and gentlemen. Good morning. I'm sorry you had to sit for 45 minutes. Couldn't have been avoided, but I apologize for the waste of time. I'll probably give your time. I'll be saying that a lot. Did anybody receive any information outside of court on this case? No. Okay. The next witness the state's going to call is the medical examiner. I'm going to read you a stipulation. It is an element in this murder in the first degree trial that Phoebe Jonchuck is the person who died. Both the state and the defense hereby stipulate that Phoebe Jonchuck was indeed the person who died in this case. You can rely on this stipulation as proof for this element of the first degree murder. You may call your witness.
Dr. Christopher Wilson.
And sir, if you would stand right here, palm and face this court, raise your right hand, prayer to you.
You do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. And now, sir, if you would have a seat in the red chair. Speak in a loud and clear voice for the court. Make sure you move up close to the mic.
Good morning, Dr. Wilson.
Good morning.
Would you state your name and occupation for the record, please?
My name is Christopher Wilson. I'm an associate medical examiner for District 6.
And how long have you been a medical examiner for District 6?
16 years.
Okay. Were you an assistant medical examiner in any other place?
Yes, in Palm Beach County for 2 years.
Okay. What other education and training have you had that qualifies you to be an associate medical examiner?
Well, I'm a fully qualified physician. I completed medical school in 1994. That was followed by a 4-year residency in anatomic and clinical pathology at the Mount Sinai Medical Mount Sinai Medical Center. That was followed by a 1-year fellowship in forensic pathology at the Miami-Dade Medical Examiner's Office, and following which I worked for 2 years at Palm Beach Medical Examiner's Office as an associate, and for the last 16 years for District 6, which is Pinellas and Pasco counties.
Do you belong to any professional affiliations or organizations?
I do.
And what are they?
The National Association of Medical Examiners, the American Association of Forensic Pathologists, and the Florida Association of Medical Examiners.
As part of your normal duties, do you perform autopsies?
I do.
What is an autopsy?
An autopsy is basically an external as well as an external examination of the body, the primary purpose of which is to determine the cause and manner of death.
And over your career, do you have an idea of how many autopsies you've performed?
Yes.
And how many would that be?
Somewhere in the vicinity of 5,500.
Okay. And have you been qualified as an expert in court as an associate medical examiner?
Yes.
Where?
In Pinellas and Pasco counties, Palm Beach County, Manatee County, and in Miami-Dade County.
And about how many times do you know?
I'd say over 100 times.
Can we approach Judge?
Sure.
On January 8th, 2015, did you perform an autopsy on a 5-year-old by the name of Phoebe Jonchuck?
I did.
Okay. Where did that autopsy was performed?
At the medical examiner's office, which is on Almaton Road.
Okay. And how do you conduct an autopsy?
Well, first I would get some basic investigation from the forensic investigator, who would be the person who first gets the information from the reporting authority. Once I get that basic information, I would proceed to the autopsy suite, do an external examination, looking for features such as the color of the eyes, color of the hair, and any external injuries. Depending on the particular case, x-rays would be done of the body. Once that's completed, I would then open up the body and perform the internal examination, which involves taking a scalpel, opening the skin, cutting the ribs, taking various body fluids for toxicology, removing the organs, weighing each organ, and examining each organ for any injuries.
In this particular case, when you conducted the external examination, were you able to determine how tall she was?
Yes. Phoebe was 47 inches in height.
Okay. And how much did she weigh?
64 pounds.
What other external observations did you obtain from your external examination?
Well, apart from features such as color of the hair and the eyes, I mean, she had medical intervention on the body, such as EKG pads, a blood pressure cuff, and she also had various injuries scattered throughout the body.
Okay. These injuries that you saw on the outside of the body, external injury, were they photographed?
Yes.
And why are they photographed?
The photograph to document the injuries in case I have to go to trial such as this.
Okay. And would those photographs be of assistance to you in showing and explaining the injuries to the jury?
Yes.
Just may I approach the clerk? Sure. Sergeant Defense Counsel with Part 66 Exhibit number 15A through Z.
You have any approach? Sure.
have to take a recess and deal with a legal issue. I'm going to hope it would not take any longer than a half an hour. That would be 10:25. Thank you for your attention.
Hold on a second, is this something we need now? Or?
No.
All right. All right. Jury's out of the hearing, Court, Your Honor.
Okay, so whoever's faster can probably his testimony.
I'd be happy to do it.
Huh?
May we approach just briefly before
Sure.
we do that? May I approach the witness?
You don't have to ask any of those things, just let's go.
Okay,
And identify the picture.
I am.
Judge, can I be up there since?
Sure, yeah, absolutely.
Since we're not putting them overhead.
This is photograph 15R, Wilson.
What was it, 15R?
Correct.
Okay.
Does this photograph show drowning?
It shows the back of the legs of the deceased.
Okay. Does that show drowning?
Not specifically, no.
Okay. Does it show where the body was found?
No,
Does it show the condition of the crime scene?
no,
Okay.
Does it show the nature and manner in which the wound was inflicted?
yes,
Okay. And you're aware that the victim was dropped off the bridge,
correct,
and that would be consistent with that occurring?
possibly.
P, does this show the manner of death being drowning?
No,
Does it show any evidence of hypothermia?
no,
Does it show the position and location where the body was found?
no,
Does it show the condition of the crime scene?
no.
Okay.
What photograph is this?
15P.
Okay. And what is that photograph of?
This is a photograph of the back, buttocks, and the back of the legs of the deceased.
Again, that would assist you in explaining to the jury the nature and manner of the wound that was inflicted?
Yes,
15Q, does this show you any evidence of drowning,
No,
hypothermia,
no,
where the body was found,
no,
the condition of the crime scene?
no.
And again, would this assist you in explaining to the jury the nature and manner of the wounds that were inflicted?
Yes.
Your Honor, I'm going to try to speed this.
Excellent.
I thought you would like that. I'm just going to page through really quick. Was the death caused by a bruise?
No.
It was caused by drowning, right?
That was the cause of death, yes.
Right, I'm handing you the rest of State's Exhibit 15. It was A through G, or excuse me, A through Z. We talked about the other three specifically. If you would page through these and then let me know when you're done. And I'm just to preview, I'm going to ask you the same questions. Do any of them show evidence of drowning, hypothermia, position and location of the body, or the condition of the crime scene? Okay, did you look through all of them?
Yes.
Okay, do any of those show drowning?
No.
Do any of them show hypothermia?
No.
Do any of them show the position and the location of where the body was found?
No.
Do any of them help explain the condition of the crime scene?
No.
Do any of the markings on the body, the bruises, or anything else really, show the cause of death?
No.
Or the contributory cause of death being hypothermia?
No.
May I have a moment, Your Honor? I don't have any further questions.
Again, this would show you and assist the jury in showing the nature and manner of the wounds inflicted.
Yes.
And part of your job is also to eliminate causes of death, correct?
Correct.
So part of your evaluation in these photographs would help eliminate other causes of death that helps you to form your opinion that it was hypothermia and drowning.
Correct.
And these photos would assist the jury with that explanation.
Yes.
Okay, anything else?
Just argument, Your Honor.
Okay, do you want Dr. Wilson? I don't think he needs to be out, but if you want me.
It's fine.
You're good to sit there if you want.
Can I take a 5-minute break to go to the bathroom?
You can, sure, go
Okay.
ahead, take as long as you want.
Okay. Thank you.
You could use the bathroom back there if you want to. Up here.
There was a bathroom back there.
Oh, yeah.
Just through it?
Yeah,
Okay.
hit it definitely, show
Thank you.
you. You're welcome. Okay, I'm listening.
Your Honor, going back, the standard for admissibility is if the photographs are relevant to prove a material fact in issue. That comes from the Florida Supreme Court in 1999, Almeida, A-L-M-E-I-D-A v. State, 748 Southern 2nd, 922. They must be relevant to a material fact in issue. As I've already cited, the Douglas case, the test for is relevancy, not necessity. And the questions I asked, did any of the photographs show the manner or contributory cause of death, that being drowning and or hypothermia. Dr. Wilson said none of those photographs show that. Number two, do the photographs show the position and location of the victim when found by police? Again, none of the photographs show that, as Dr. Wilson said, and he said, do any of them explain the condition of the crime scene? No, they do not. And he said none of those photographs show the, I just said that, the manner and cause of death. I would suggest that the state asked, do they show the nature and manner of wounds? She was not killed by a bruise. We know that she was killed due to drowning. If somebody had been hit with blunt force trauma and there was evidence of bruising that showed that, clearly that would be relevant to prove the cause or contributory cause of death. These photographs are cumulative, and of course the court always has to do the 403 analysis for any evidence that is presented, and you know, the material fact and issue here is how did she die? We have not put that in issue. We have never challenged, but that is what happened, and would certainly stipulate to anything, you know, about that. I mean, it's just not an issue. And as far as eliminating other causes of death, I'm not sure how showing a photograph of a bruise eliminates another cause of death such that, or to the extent that it would be more probative than prejudicial. And certainly we can think of cases where that is the situation, where there are other things that have to be ruled out, but that's not the situation here. They do not do anything as to proof of a material fact and issue, and we ask that they be excluded.
Judge, I'd cite Harris versus State 843, Southern 2nd 856, a 2003 case from the Supreme Court of Florida. In that case, the court held, we have consistently held that the initial test for determining the admissibility of photographs is relevant. Photographs are admissible if they assist the medical examiner in explaining to the jury the nature and manner in which the wounds were inflicted. Moreover, the photographs are admissible to show the manner of death, location of wounds, not lethal wounds, the location of wounds. If there was a stabbing in which the defendant would stab the victim 10 times, one of them only was fatal, all those other 9 cuts or stab wounds would be admissible to show the nature and location of those wounds, even though they weren't the fatal blow, so to speak, under the case law, and the identity of the victim. They said they indicated they never challenged the manner and cause of death. They ran a whole motion on hypothermia, so they have challenged that. Also, the bruising is consistent with the fall. The medical examiner said she was dropped, learned that she was dropped off the bridge from his investigator, and that's consistent with that fall, which helps confirm the manner in which the fall occurred. She was dropped from a great distance into the water, and then that led to the drowning. So it's a step-by-step process. And I think because of that step process, the fact that the location and manner of wounds are admissible, this examiner has testified his expert opinion they would assist the jury, which is required in the law, and I can give the court a copy of Harris.
Can I see it? Is it just in that folder? Can I just see it? Thank you. Do you have this?
No.
And therefore, Judge,
Do you have the sites we pulled up?
843 Southern 2nd 856 Supreme Court. Okay, I'm gonna allow some of it in pursuant to Harris, that they definitely, my understanding from Dr. Wilson is obviously the nature and manner of death. I don't know how much hypothermia stuff we're gonna hear, but we're gonna hear drowning, and the fact that those bruises were there would be relevant to the manner in which she was placed into the water that led to her drowning, but I'm going to severely limit the quantity of those photos. And I don't,
Judge, and you have to determine what one I can use.
I know, I think you can use a few. I think you can use one photo of each wound that she would have sustained as she was being thrown in the water, whether the water hit it or the piling hit it or whatever hit her. Because my understanding is there's no prior injuries to this child.
Can I approach?
Sure. And I am somewhat one face shot, and that's it. You need some time, or are we ready?
You want me to pick them out and you're going to approve them?
Well, show them to the defense, because they know, I mean, pick one
Well, they're
out.
objecting to everything, so I don't.
Well, we're already past that. You get one picture.
Unless you're first judge.
No.
You want me to announce for the record which ones I showed them?
Well, hopefully they're going to agree, and we'll just be moving on.
Are you waiting for us or something?
Yeah, I mean, they're picking out one, they picked it out. Do you have any argument as to the one that they picked out, like you want a different one? And I'm not gonna necessarily say that we're gonna spend a lot of time on it, but.
I'll just stand by the objection to all of them.
Awesome, okay, so those are the ones that are coming in. I don't think you need to make any kind of record, just do it. Okay, let's bring the jury in, please.
Liberty Rice, line them up, bring them in.
Andrew's first name
Hmm?
on the stipulation? John.
Oh, sorry.
Four.
You want to cough drop?
That might help, thank you.
You can take more than one.
Sure, thank you.
Oh, thank you. Can you hold just a second?
Deputy Rice, hold on.
Let's come up with a question. Deputy Jocelyn, remind me of that. Yes, please.
All right, Deputy Rice, bring him in.
Thank you for reminding me.
who's in the jury box and see her, John.
Okay, ladies and gentlemen, I have one question, so I have to read it to you all and figure out who wrote the question. When in custody in Manatee County, Mr. Jonchuck went to the restroom. Is it general practice to observe the defendant, or was he allowed to use the restroom in private? If I could ask who wrote the question.
I just know.
Okay, thank you. I have to note that. And your name is?
Myra, it was
Thank you. And did you write that this morning or yesterday?
Yes, ma'am.
Okay. The witness who could have testified about that is been excused, is that correct? I think so.
Yes, sir.
Okay. We are going to try to get the answer through another witness who has yet to testify.
Thank you.
You're welcome. You may proceed.
Judge, this time I introduce this exhibit number 15, I, O, Z, Q, R, W, P into evidence and published. May I publish them to the jury?
Yes, received over defense objection.
Sure, what's the March State's exhibit number 15, P. What is that a picture of, Doctor?
It's a picture of the back, the buttocks, and the back of the legs of the deceased.
Okay. And what is that number in the picture?
That's a specific number that we give to each case. In this particular case, the number was 5150043.
So that was tied to Phoebe Jonchuck.
Correct. It's a unique identification number.
Okay. And would you? What is this area? What are the injuries here that you're seeing?
That's the back of the left thigh, and you can see this on the upper aspect near to the buttocks is very clear, sharp line of demarcation between the upper and the lower aspect, and you see that.
Would you stand up and show us with your pointer, please?
Sure.
That's all right, Judge?
Yeah, that's fine.
I'm referring to this area here, which, as you can see, has a purplish reddish discoloration. That's a contusion or a bruise. And the significant thing to this injury is how very sharp this line is here, as well as the circular areas of paleness here, indicating to me that this is a patterned abrasion. You don't get this from, some irregular object hitting the skin. This is clearly a pattern of something with a sharp line here and two holes here hitting the skin.
Would be consistent with someone being thrown off a bridge and perhaps hitting a pylon or something?
Yeah, it depends. I mean, when I looked at this particular injury at autopsy, I specifically asked if there was anything on the bridge, maybe some rivets on the side of the bridge that she might have impacted. As far as I could determine, that was not the case, but it had to be some specific object that she hit.
And stand, this is 15W. What is that the picture of?
Again, that's a close-up of that previous injury. Again, note the paleness here and the very sharp line of demarcation of the bruise here, as well as these patterned circular areas of pallor within the actual bruise, indicating that this is a pattern contusion, pattern bruise from some object of that shape impacting the back of the left thigh.
And what is that a picture of? This is 15R.
This would be a picture of the back of the thighs going down into the lower legs and the feet. Again, on the upper aspect, you see that pattern abrasion. And as you come along here, you can see some areas of contusions on the back of the left thigh and maybe an abrasion on the left ankle here.
And this is 15Q.
This would be the back of the head, the neck, and the upper back of the deceased. Of significance would be this area on the left back, where you can see these purple areas of discoloration, which again are contusions or bruises as some blunt object or objects hit the back of the deceased.
This is 15Z.
Again, this would be the back of the head going into the neck here. A closer up picture of the back of the left shoulder going into the left upper back. And this is a close-up of one of those contusions or bruises on the left upper back.
15O.
This would be a photograph of the lips of the deceased, upper lip, lower lip, teeth, and specific reference from the ruler, right above the ruler, is this area of abrasions, possibly a laceration on the lower lip of the deceased.
The color of the lips,
The lips look, well, the lips look kind of cyanotic or blue in appearance, probably because of the room temperature of the deceased.
and 15I.
Photograph of the front of the legs of the deceased. This aspect here would be the thighs, going into the knees, going into the lower legs. You can see evidence of medical intervention in these intraosseous catheters, and you can see various areas of purple discoloration on the left knee. Again, these are contusions from blunt objects hitting the deceased.
That's all the picture photos we have. After you conducted your external examination, did you conduct an internal examination?
I did.
And what did that reveal to you?
Basically, there was the lungs had what are called petechiae on the external surfaces or the pleural aspects.
What does that mean, petechiae?
Petechiae are like pinpoint hemorrhages on the surface of any body tissue. In this particular case, the lungs usually occurs when very small blood vessels rupture and can be found in cases of asphyxiation.
Asphyxiation is unable to breathe?
Basically, it really refers to the lack of oxygen. Could be caused by any number of things. The most common being somebody choking, somebody asphyxiating, like say on a steak if they happen to swallow the steak and it sticks in the throat, or in drowning.
Okay. What else did you discover during your internal examination?
Within the lungs, within the bronchi, which are the tubes that go into the lungs and go through the lung architecture, was copious frothy fluid. Again, that's seen in cases of drowning.
What history did you have from your investigator regarding the death of Phoebe Jonchuck?
So the basic information was that
Hearsay?
Go ahead.
basic information was that the girl was thrown over the Dick Meisner Bridge by the father. The body was recovered about 90 minutes after that event occurred, taken to the hospital where they attempted resuscitative efforts, and after 30 minutes she was pronounced deceased.
What was the height of the fall?
Approximately 60 feet.
And what was the air temperature?
I don't know what the air temperature was, but according to my investigator from Bay News 9, the water temperature was 67 degrees in January of 2015.
Do you know how long she was in the water?
Approximately 90 minutes.
Okay. And why is it important to know that surrounding history when doing your examination?
Well, you know, this is the Tampa Bay area. In cases of drowning, I mean, there's no really specific set of findings that would definitely, you know, indicate that somebody drowns. I mean, it's basically on the circumstances such as whether the person can swim, how well they can swim, currents in the area, that type of stuff. Also, with respect to contributory condition of hypothermia, you need to know what the temperature of the water is, how long they're in the water, things like the core temperature when they came out, how long
What
it took.
was the core temperature of Phoebe Jonchuck when she came out?
In the ER, the core temperature was recorded as 7 degrees Celsius, which is 44.6 degrees Fahrenheit.
And what's the normal temperature?
Normal temperature would be 98.6 degrees Fahrenheit.
So this is about half or so the normal temperature, even less than half?
It's very cold, yes.
Were they able to raise her temperature in their life-saving efforts?
They did. They surrounded her by warm blankets and infused warm IV fluids and got her temperature up to 24 degrees Celsius, which is 75.2 degrees Fahrenheit.
Were you able to determine within a reasonable degree of medical certainty the cause and manner of death?
Yes.
And were you able to, within a reasonable degree of medical certainty, determine any contributory conditions?
Yes.
All right. What was the cause of death?
Cause of death was drowning.
What was the manner of death?
Homicide.
And what was the contributory condition?
Hypothermia.
The bruising that we saw, does that have to occur while you're alive?
Absolutely. In order for a bruise to have that purplish appearance, it means that the blood vessels under the skin have ruptured and blood is actually flowing into the injured area. So for blood to flow, the heart has to be pumping, so the person is technically alive.
Yes. The frothy fluid in the lungs that you described,
Yes.
that is evidence of drowning?
It's a finding. It is not necessarily pathognomonic of drowning, but it is found in many cases.
And the petechiae in the lungs, similar?
Yes, again, found in cases of asphyxiation, of which drowning is a reason to asphyxiate.
The photographs that the state judge just presented to you, none of those photographs proved drowning, correct?
Not in it and of themselves, no.
Okay. Or showed any external evidence of that?
Of drowning specifically?
Correct.
No.
And same with hypothermia. None of those photographs showed direct evidence of hypothermia, correct?
Correct.
Okay. Nothing further?
Anything further?
Part of your job is to rule out other things that could have happened?
Yes.
And so you, in your examination, you ruled out other possible causes of death?
Yes.
Okay. And you determined that it was drowning with a contributory factor or contributory condition of hypothermia?
Correct.
And those photographs are consistent with someone being dropped off the bridge and the impact and impacting. Those photographs are consistent with being someone being thrown off the bridge and impacting the water and impacting things in the water, consistent with the story you gave, which would be consistent with the drowning.
Correct.
Nothing further, Judge.
Anything further? Okay. Can Dr. Wilson be excused?
Yes, Judge.
Defense, would you want him on standby?
No, you're
Okay. Thank you for your testimony, Dr. Wilson.
Thank you.
Anybody have a question for Dr. Wilson? Raise your hand if you think you do. Okay. Thank you, Dr. Wilson.
Thank you.
Let me call your next witness.
State Coast Detective Thad Coffin.
Sir, if you would stand right here, please, clerk, raise your right hand, correct, take you.
Do you solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. And sir, if you would have a seat in the red chair. Speak in a loud and clear voice for the court, make sure you move up close to that mode.
Okay, thank you. Good morning.
Would you please state your name for the record?
Thaddeus Coffin,
And how do you spell your first and last name?
Thaddius, and last name Coffin.
And how are you employed?
I'm a detective with St. Petersburg Police Department.
How long have you been with the St. Petersburg Police Department as a police officer?
About 14 years.
And can you briefly describe your training experience leading up to your current assignment?
My current assignment right now is digital forensics and computer crimes. Throughout my time at the police department, I was a police officer and then became detective to my current assignment. In order to do the things that I do, I've had a lot of training in reference to digital forensics and computer investigations. Some of that training includes training on how to dump information from cell phones and how to conduct computer crimes investigations. Specifically, taken classes from XRY, which is a vendor that dumps information from cell phones. Taken classes from Teal Tech, which are much more technical in that they require you to kind of get down and dirty with the cell phone. So the specific classes I've taken with Teal Tech are bootloader and flasher box, ISP, which is in-service programming, chip-off forensics, which involves removing a chip from a cell phone. I've also taken several classes and trainings for examining computers. A lot of those are sponsored by the federal government and other folks. So I've taken SCURS, which is sponsored by Department of Homeland Security, and I've taken Axiom programming class. I'm sorry, an Axiom computer review class, which includes parsing through data from a computer.
I'm sorry, can you repeat what you did for the last part?
Yeah, taking an Axiom, AXIOM, kind of computer review class, which entails parsing through data from computers.
So you told us about your experience and some of your training. What are your day in and day out duties as the computer forensic detective for the St. Petersburg Police Department?
Day in and day out duties focusing on digital forensics includes people, other detectives mainly bringing me electronic devices to try and get information from. So depending on the case, it can be more intensive.
Are you the primary computer forensic detective for the entire St. Petersburg Police Department?
I am the main one, yes.
In this case, did you have an occasion to examine a cell phone, a smartphone?
I did.
Was that the smartphone belonging to the defendant, John Jonchuck Jr.?
It was, yes.
Okay. So can you tell me what you were tasked with doing with this phone?
This phone had been recovered from the scene and was not able to turn on. So my task was to get the data from the phone.
Now, when you received the phone, can you describe the condition of the phone when you received it?
Yeah, it was a whole cell phone, except the screen was damaged, severely cracked. And again, when I tried to turn it on, it would not turn on.
So what did you do from that point?
From that point, you have to try and get power to the device. In this particular case, batteries often fail, so I took out the battery and used what we call banana clips. Banana clips are basically hardwired power source to a phone, so you don't have to charge it or anything like that. It plugs in to a USB device and then powers the phone directly. That did not work either. After that, because there's no power to the phone, we had to move on to more extreme methods to try and get the data from the phone.
And what were those methods that you used?
The chip-off process.
Okay, can you describe the chip-off process to the jury?
Yes. So the chip-off process, you have your cell phone, and inside the cell phone there's a motherboard. On the motherboard there's all kinds of chips and transistors and capacitors and whatnot. The data that rests on a cell phone is on one chip, one microchip. So your goal on a chip-off is to remove that chip and dump the data from that chip directly. Typically don't like to do this because it is destructive to the phone. This is the last resort to try and get information from the phone. So in this case, that's what I had to do. Utilized the methods that we have, pulled the chip off, and I was not able to get a dump from the chip.
You were not able to get what from the chip?
Information dump.
And that's a common term that's used by forensic experts, correct?
That's correct, yeah.
All right. And are you referring to data?
Yes. Data.
So by taking the chip out, you said that there was damage to the actual plastic components of the phone, correct?
Yes.
Does that in any way impair the data that's on the chip?
No, definitely not.
Okay. So would the data still be on that chip even though the phone was dismantled to get to the chip?
Yes, and that's the purpose of the chip-off process.
Can you tell them in detail what you did with the chip, starting with how you removed it from the phone and how you attempted to extract data from it?
Certainly. So this particular phone, the method that we have here locally is to use heat to melt a chip off of a motherboard. And essentially the chip is attached by solder and by epoxy. So you have to heat that up in order for the solder and epoxy to melt. That way you can lift the chip off. This particular phone had a chip on the bottom side, the processor on the bottom side. So the method that we prefer to use is bottom heat, what we call bottom heat. So we put the motherboard on a heating plate so heat comes up from the bottom and heats up the motherboard slowly, because we don't really care about the motherboard. Our goal is to get the information off of the chip. So slowly start heating that up, but because of the chip on the bottom, it was absorbing a lot of the heat from our target chip, the memory chip. So I had to use top heat to blow heat down onto the memory chip to melt that solder and that epoxy. Eventually, the chip came off, and after that, I have to clean it up and attach it to, I have to clean it up and then what we call reballing. So on the bottom of microchip, there are all kinds of very tiny, tiny little pads, probably 100 or so on a small little microchip this big. So you have to reball those little pads so that with solder, so that you can attach wires to them and pull out the data. In this case, I got the chip reballed, put it in our chip reading adapter, and attached it to the computer.
Can you explain the reballing process?
Certainly.
What do you do to reball?
Yep. So in order to reball a chip, you pull it off the motherboard. It's dirty, it's grimy underneath, it's got epoxy, it's got solder all over the place. It's just a nasty mess. You have to clean it up with a soldering iron. You have to clean all that off using a microscope or some sort of magnifying device. Clean it all off, make it nice and pretty, and then you apply soldering paste, which is almost like applying butter to a piece of toast. You just slap it on, and then you apply some heat, and just like butter, it melts. Except within that soldering paste, there's solder, and that attaches itself, self-attaches to the pads on the microchip. That creates kind of the soldering beds that we want to implant the wires or attachments to. That way we can read the information off of the chip.
And did you do that in this case?
I did, yes.
And what happened?
Nothing. I could not get a good read.
Okay. And how many times did you attempt to get a good read off that chip?
Approximately 8 to 10 times. I tried several times.
And each time, your 8 to 10 times, you were unsuccessful?
That's correct, yes.
And in that process, was the chip damaged at all?
No, no. It looked to be fully functioning, clean. The pads look good.
Is the chip still in good shape?
It is still in good shape.
Was the chip and the other components of the phone provided to the defense in this case for John Jonchuck Jr.?
It was, yes.
Okay. And what we are? To your knowledge, has that chip and the components with the chip been returned to the St. Petersburg Police Department?
I don't know that it has.
That's all I have.
Ross?
afternoon, or morning still. Good morning, Detective Coffin.
Good morning.
All right. Now, may I approach the witness? I'm approaching, I'm showing you what's been pre-marked as defense 4A through 4D, marked for identification. Can you take a look at those? Let me know if you recognize.
I do recognize them, yes.
All right. And what do these photos depict?
They're pictures of the result of the phone after the chip-off process.
Okay. And do they fairly and accurately depict the phone as you left it?
Yes.
Okay. At this time, Judge, I'd ask to introduce to evidence defense 4A through 4D.
No objection.
No objection.
Receive.
So, fair to say you indicated that the phone was turned over to the defense in this case, right?
Yes,
And this is the condition of the phone when it is turned over to the defense, correct?
that's correct. Yes.
Permission to publish? Yes. Now, when the phone was provided to us, you were not even listed as a witness, correct?
I assume, probably correct, yeah.
And you did not write a report in this case, correct?
That's right.
So, and do you know what date you were listed as a witness?
No.
Objection, Your Honor, that's completely irrelevant.
There was some insinuation that the defendant...
Come on up, come on up.
prior to you obtaining the phone, Lisa Vanderbilt had the phone, correct?
That's correct.
She's a
yes.
detective with St. Pete, correct?
She is, yes.
And she wrote a report basically just indicating she couldn't get anything off the phone, right?
Objection to hearsay.
It's the same. I'm gonna overrule that. Go ahead.
She wrote a report indicating just basically the bare minimum, I couldn't get anything off the phone initially, right?
That's correct, yes.
And after her deposition, you were contacted by the state about coming in to explain further, correct?
Objection again to hearsay and irrelevant.
Overruled.
Yes.
Okay. So up to that point, nobody had asked you to provide any report detailing this chip-off procedure, right?
Not to my recollection.
Okay. And so when the defense took possession of the phone, it's in a bag with all these pieces and there's no report explaining why, correct?
Right.
Okay. Now, you received the phone on November 20th of 2017, right?
That's correct, yes.
And your, with the time you received it, the phone was not operable, right?
That's correct, yes.
But you believed it was a good candidate for the chip-off process, correct?
I did.
And part of that reason you believed it was a good candidate for the chip-off process is because the phone was operable at the time it was collected, correct?
Yes.
Now, you were trained in this chip-off procedure yourself in October 2017, correct?
Correct.
And this case you handled in November 2017, right? November 27th, I believe?
Yes, ma'am.
Is that right? Okay. Fair to say you're the only St. Pete detective or officer that is trained in the chip-off technology, correct?
Yes.
And so when you did this, you went down to PCSO to kind of have, they have the technology and to also kind of assist, right?
Yes.
So there's somebody in law enforcement locally that, other than you, that knows how to do this chip-off procedure, right?
Yes.
Okay. Fair to say you are not aware of any experts who do this procedure for defense attorneys?
That's correct.
You tried a number of times to build up the chip and be able to get some information from it, right?
Yes, ma'am.
Unfortunately, you weren't able to, right?
That's correct.
But you're not willing to give it another try either, right?
No, I mean, once you get to about 10 tries, more is kind of irrelevant.
Okay. And as far as why you're unable to get any information from the phone, you can't really say if it was a problem in perhaps building up the nodules you were talking about, or if there was some prior damage to the chip, correct?
That's right, I cannot say.
Okay. And some things that could damage the chip could be water damage or heat, those kinds of things, right?
Yes, ma'am.
Dropping the phone.
Yes, ma'am.
And absent there still being water sitting in the phone, you wouldn't know if any of those things happened, right?
That's correct.
So the phone could have been damaged during the course of storage or something, correct?
Yes, ma'am.
I don't have anything further.
Anything further from the state?
Just briefly, Your Honor. Detective, who asked you to do this chip-off procedure?
Detective Vanderbilt said that she couldn't succeed with getting a data dump or get the data from the phone through our normal processes. So she suggested it was confirmed with Detective Miller that it was authorized, and then I went forward with it.
Okay. And so were you getting your instructions to do the chip-off procedure from Detective Miller?
Yes.
Is he the case agent in this
He
case?
is, yes.
And Detective Vanderbilt is also a detective who does forensic work?
Yes, she does. Yes.
Who is more specialized, Detective Vanderbilt or yourself?
I am.
And the photographs that were just shown to the jury of the phone, who took those photographs?
I believe the defense did.
Okay. And did you also document the phone as well in photographs?
I did, yes.
Okay. Did you document the different stages of your procedure as you did the chip-off through photographs?
Yes, I did.
Okay, and were those provided and made available?
Yes, they were.
All right. And you said you did not write a police report. Do you always write a police report every time you do a chip-off?
I certainly try, but we get extremely busy, so not every time, no.
All right. But did the photographs fairly and accurately document what you did in this case?
They did.
Okay. Have more, Your Honor?
Sure.
Go ahead.
Anything further? No, Judge. Okay, can Detective Coffin be excused or stand by?
Stand by, Your Honor.
All right, you're on stand. Oops, any questions of Detective Coffin? No. All right, you're on standby. Thank you for your testimony.
Thank you, ma'am.
You may call your next witness.
State Police Officer Michael Carter.
And sir, if you would stand right here for me, please. Face this court. Raise your right hand and start to take the oath.
You do solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
And now, sir, if you would have a seat in the red chair. Speaking a loud and clear voice for the court, you can walk close to the mic.
Good morning, officer.
Good morning.
Morning.
Good morning.
Would you please state your name for the record?
Michael W. Carter.
What is your occupation?
I am a police officer of the city of St. Petersburg, Florida.
And how long have you been a police officer?
Approximately 16 years.
What's your current assignment?
I am working in our downtown deployment unit.
Okay. And what are your duties there?
I work with the bars in the downtown area.
Okay. And do you sometimes work with Officer Julie Bryan, who works there as well?
Yes, I do.
And what was your assignment on the evening of January 7th, 2015?
On this night, I was working the bars downtown. I was in the area of the 100 block of First Avenue North.
So I want to draw your attention to just after midnight, which would be the first few minutes of Thursday, January 8th, 2015. Did you receive a radio traffic that something had happened?
Yes, there was a radio transmission of a officer who was behind a vehicle that was stopped on the Dick Meisner Bridge, and the subject got out of the car, removed a child from the car, and dropped him off the bridge.
What did you do when you heard that?
At that point, I got in my vehicle and I responded to the area.
Okay. And where'd you go specifically?
I went first to the north fishing pier and circulated the area, trying to locate the vehicle at that point.
Okay. And were you in a marked police cruiser?
Yes, I was in a marked police cruiser at the time.
Full uniform?
Full uniform.
Just like what you're wearing today?
Yes.
Okay. And so, where's the north pier in relation to the Dick Meisner Bridge?
It's in between the Dick Meisner Bridge and the Skyway itself, Skyway Bridge itself.
And did you have any car cameras or body cameras at that time?
No, I did not.
Okay. So, did you see anything related to this case when you were at the North Pier?
When I went by the Dick Meisner Bridge, the officers were still on scene trying to locate the female at that time.
Okay, but you kept going and went to the
Yes,
pier?
I continued going, trying to locate the vehicle.
Okay. Which vehicle were you looking for?
The white PT Cruiser.
Okay. And did you see the white PT Cruiser anywhere north of the Skyway?
No, I did not.
What happened next?
When I was in that area, it was called out that that the vehicle was located and was going northbound. It had went northbound from I-275 on to 75, and a officer was behind it. Officer Gillis had gotten behind the car and was trying to pursue the car at the time.
Okay. What happened next?
At that point, Officer Gillis called out that the car was doing a U-turn, was coming back at her, and then started going southbound in the northbound lanes of I-75.
What did you do?
At that point, I continued southbound on I-275, on to 75, continued southbound until I was able to catch up with the pursuit, which was just north of exit 213 on 75.
Do you remember how fast you were going to get there?
At one point, approximately, I was doing about 137 miles an hour southbound on I-275.
Were lights and sirens activated?
Yes, sir. Lights and sirens activated, and everything going.
What did you see when you arrived at exit 213 on Interstate 75?
At exit 213, that's just north of there, I was observed the Highway Patrol and Sheriff's Departments from other agencies. I had the road blocked from the northbound lane to keep from the traffic from flowing. I saw other vehicles behind the vehicle in pursuit, and at that point, observed the car coming to a stop.
What happened next?
At that point, I pulled into the median, exited my vehicle, approached the vehicle that had stopped in the northbound lanes. I observed a deputy having the driver at gunpoint, and I approached, along with 3 other officers, the driver's door of the vehicle.
And what was the make and model of this vehicle?
It was a white PT Cruiser.
What was the tag for the vehicle?
It was Delta Echo Romeo Papa 27.
Okay. What happened?
At this point, the gentleman that was in the vehicle was hands on the steering wheel, looking straight ahead, not responding to any commands that the officers were giving him at the time. He refused to unlock the door. He refused to exit the vehicle. At this time, an officer, Souza, made a decision to smash out the glass to try to remove the subject from the vehicle.
Which St. Petersburg officers were there with you?
The officers from St. Pete were Officer Gillis and Officer Laberte and Officer Souza,
and
along
where,
with myself.
And where were you in relationship to the defendant who was sitting in the vehicle?
I was at the driver's side mirror by the front fender at that point, and the other officers were in between me and the rear of the car.
Okay. So what happened after Officer Sousa broke the window?
After the window was broke, the defendant still did not respond to commands. We tried to extract him from the car. At that point, his seatbelt was still attached, and we could not extract him from the car.
Okay. Was this a tense situation?
Yes, very intense. People were still yelling commands at him at the whole time. He was still holding on to the steering wheel and was refusing to let go.
What happened?
At this point, we realized that the seatbelt was still buckled on, and we had to have somebody come in from the passenger side to unbuckle the seatbelt because none of us could reach it from the driver's side.
And what happened after the seatbelt was unbuckled?
Once the seatbelt was released, we were able to extract the subject through the window of the car, put him on the ground, and get him in handcuffs.
And what was the reason they just didn't open the door from the exterior of the vehicle? Was the vehicle locked?
The vehicle was locked, but at that point, with the situation being intense, and with him still holding on to the steering wheel, he was pulled through the window of the car with it being smashed out.
And what happened after he was pulled out?
He was pulled out, he was placed on the ground, he was handcuffed. At that point, he was escorted back to his feet. He was escorted to my cruiser, which was parked in the median, which was the closest cruiser at the time.
Okay. Approach the witness. Officer, I'm showing you some photographs. These are states 13A through 13P. Would you take a look at those without showing those to the jury? These photographs fairly and accurately depict the defendant and also the white PT Cruiser that you just testified to.
Correct, they do.
Your Honor, at this time, the state is asking to admit into evidence what is pre-marked as states 13A through P as 13A through P.
No objection.
Received.
Wish to publish?
Yes.
Officer Carter, if you'll just turn your attention to that monitor over your shoulder. this the white PT Cruiser that you were just testifying about?
Yes, it is.
Was this photograph taken when the vehicle came to a stop at the roadblock in Manatee County
Yes.
at exit 213? And that was 13A. It's 13B. Is that the interior of the vehicle?
Yes, it is.
That shows some of the glass from the window being broken.
Right, from the glass being smashed out towards the inside of the vehicle.
It's 13C. Similar view of the interior of the vehicle.
Correct.
It's 13D. From the other angle, correct?
Yes, it is.
It's 13E. Is this the backseat area of the vehicle?
Yes, it is.
This is 13F. What is this?
That is a child's booster seat.
It's 13H.
That's from the passenger side door.
This is 13I. Where's this?
That's the rear trunk of the car.
L.
Same picture as before, just a further view out with the license plate in the picture too.
What is the license plate in this photograph?
DERP27.
Is that the same tag called out by Officer Vickers?
Yes, it is.
This is 13J. Where's this?
It's the rear trunk of the car.
And what are these items?
It looks like child's toys.
(13N).
That would be the driver's side of the vehicle.
13O.
That's from the front passenger side.
This a police cruiser here,
Correct.
part of the roadblock.
Yes.
We have 13K. Again,
That's a picture of the license plate, as we stated from earlier.
13P. Who's that?
That is Mr. Jonchuck, as he was taken from the vehicle and transported to St. Pete's station.
Was that photograph taken at the St. Pete station,
Yes, it was.
January 8th, 2015?
Correct.
That's what he was wearing when he was extracted from the vehicle?
Yes, it was.
Did the defendant make any spontaneous statements to you when you transported him from the Manatee County roadblock where he was arrested to the Manatee County Sheriff's Office?
Yeah, he made two spontaneous statements. One was, the first one is she will only live with him, and that he asked for me to take him to the Tampa airport.
Okay. And did you ask him any questions to elicit those statements?
No, I did not.
Okay. Was it your job to ask questions while you transported him?
No, it was not. My only job was to transport him from the scene to the Manatee Sheriff's Office.
Okay. And did you also transport him from the Manatee County Sheriff's Office to St. Pete Police Department?
Yes, I did.
Okay. And from there To where?
To the Pinellas County Jail.
Okay. Now, when you were at the Manatee County Sheriff's Office, did you stand by with him?
Yes, I stood by outside the interview room for the entire time that we were there.
All right. At some point, did he go to the bathroom?
Yes, at one point, myself and a Manatee County deputy escorted him to the restroom.
Okay. And was he allowed to go into the restroom by himself?
No. Anytime anybody's in custody, they have to be monitored the whole time. We actually stepped inside the restroom while he was there.
All right. What was his demeanor like when you were seeing him at the Manatee County Sheriff's Office and transporting him?
He was very quiet, non-emotional, except for a couple of times he would almost appear to be trying to make himself to forcefully cry. And then that time would only last.
You can answer.
Would only last for like a couple of seconds, and it would just go back to like a blank look.
It didn't appear to be genuine crying to you?
No, it was not. It was like he was forcing himself to create tears.
How many times did that happen?
A couple of times.
When you were transporting him from the St. Petersburg Police Department after the photographs were taken and clothing was collected to the Pinellas County Jail, did he make any spontaneous statements on the way to the jail from St. Petersburg Police Department?
Yes, he made 3 spontaneous statements at that point. He said at one point he did not throw her off the bridge, that he dropped her into the water. He stated that you don't know what I've been going through, and he also made a statement as he did not know what he did wrong.
Okay. Was he booked into the jail?
Yes, I stood by until he was booked in the Pinellas County Jail.
Do you see him in the courtroom today, the defendant that was extracted from this white PT Cruiser that you helped extract from the PT Cruiser and that you transported that night?
Yes, he's sitting in the over here to the left in a white button-up shirt with a tie on, tan pants.
Yeah, would the record reflect that the witnesses identified the defendant?
Yes.
Have a moment, Your Honor. That's all I have, Your Honor.
Cross.
One moment, Judge.
Ms. Irizarry, did that answer your question?
Yes, ma'am.
Okay. And in the future, if anybody has a question, that's the way to do it. Write it on a piece of paper, hopefully before the witness is gone and available for that. Thank you.
Morning, Officer Carter.
Good morning.
You mentioned when you were heading out to the scene of the traffic stop, or where Mr. Jonchuck actually came to a stop, you're driving about 137 miles per hour at some point, right?
Yes, I was.
fair to say that's you playing catch up, right?
Yes.
There was no indication that Mr. Jonchuck, after leaving the Dick Meisner Bridge, was ever going over 70 miles per hour, correct?
I have no call. I can't say that.
Would it refresh your recollection to review the dispatch notes you referred to a number of times?
Yeah.
May I approach the witness, Judge? Sure.
Can I see that?
What is this? The dispatcher notes?
The dispatch notes, yeah. Refreshes your recollection on whether anybody ever indicated he was going faster than 70.
That would be the officer calling that out that was behind him.
So that'd be up to Sousa's account then, right?
Yes. No.
So you don't have any information he was going anything over than 70, then, right? Sousa, is there anything in there that suggests that?
No. Not from what I'm seeing here.
Your Honor, I'm going to object. She was refreshing his recollection, and now she's questioning about the document.
So the first time you have eyes on the car's already come to a stop, right?
Yes, it was coming to a stop. It wasn't at a complete stop yet, but it was coming to a stop.
All right. And the officers all start surrounding the vehicle, correct?
Correct.
Number of officers, right?
Yes, like I stated earlier, there was a Manatee deputy already had him at gunpoint.
Right. And shouting commands, right, at him?
Yes.
And multiple officers had their guns drawn, right?
He's the only one I saw, but yes, probably, I'm guessing yes, so.
You were most focused on Mr. Jonchuck, right?
Yes.
And at no time did you see him do anything other than continue to grip the steering wheel as he drove up, right?
Correct, at that point, yes.
So he drove up gripping the steering wheel and he stayed gripping the steering wheel, right?
Yes, until we pulled him out of the car, yes.
And stared straight ahead, right?
Yes.
Not responding to any commands that anybody's yelling at him?
Correct.
You guys start breaking out the windows, doesn't respond to that, correct?
Correct.
He doesn't ever turn his gaze from straight ahead, correct?
No, he did not.
And to be clear, you guys had to break out multiple, or you did break out multiple windows, right?
Yes.
Okay. And when you got the window broken out, you couldn't get him out because the seatbelt was fastened, right?
Correct.
There was a child car seat in the back seat, right?
The booster seat, yes.
Booster seat behind the passenger side?
Yes.
Once you were able to, or you all were able to undo the seatbelt, he didn't struggle with y'all as you were trying to pull him out of the car, right?
No.
Just basically dead weight, right?
Dead weight, and he still had a hold of the steering wheel.
Okay. And he never pulled himself away or anything from y'all, right?
No.
Okay. No indication that Mr. Jonchuck was under the influence of alcohol or drugs, correct?
Not that I could tell at the time.
And you had eyes on him. You drove him to Manatee, right?
Correct.
And you had eyes on him at Manatee, correct?
Correct.
Now, St. Pete Police Department doesn't wear body cams, right?
No, we do not.
And hardly have any cruisers with cameras in it also, right?
I do not have one in mind.
The cruiser that Mr. Jonchuck was placed into doesn't have video recording, right?
As I said earlier, I do not have a camera in my car.
It's a fully marked police cruiser that you were in though, correct?
Correct.
You got a light bar on top, right?
Yes.
You have the insignia on the side?
Yes, I do.
You got the cage in the back?
Yes, I do.
Okay. While John's sitting in the back of that car, he starts asking for his Bible, right?
He didn't ask me for it, but there was a sergeant at the time that was talking to him, yes, and I was asking for a Bible.
And you transported that giant Bible to Manatee County Sheriff's Office, correct?
Correct.
So somebody retrieved it from Mr. Jonchuck's car, and you took it with yourself and Mr. Jonchuck to Manatee, right?
Yes.
It wasn't knocking, was it?
No.
No? When Hubble is speaking to him in the back of the car, you can't hear, or you're not privy to the entire conversation, right?
No, I could not hear. There was cars going, sirens going. I couldn't hear the conversation in between Sergeant Hubble and Mr. Jonchuck.
But you do hear John say something about Michael, right?
I don't know if I heard it from him or if I heard it from somebody else making a statement.
So either he or somebody else said something about Michael to him?
Not that I recall, but something was said about it.
You don't remember what was said?
No.
You told John that you heard him saying something about, you heard John talking about Michael when he was in the back of your car, right?
Not that I recall.
Would it refresh your recollection to review the transcript from Manatee?
From Manatee?
Mm-hmm.
Yeah.
You were there, right?
In Manatee County, yes.
Okay. May I approach the witness, Judge?
And this is the transcript from, you're saying from Manatee, what of from Manatee?
The interrogation room.
Okay.
Does that refresh your recollection about what you said to John?
Yes.
And you agree that you told John that the first thing he was saying at first was something about, what he was saying at first was something about Michael out there at the scene, right?
Yes.
You would agree you didn't include that anywhere in your police report, correct?
No, I did not.
I'm guessing you don't have any additional details about what he said about Michael for us today, do you?
No, I do not.
Objection, that's argumentative.
Do you have any additional details about what he said about Michael?
No, I do not.
Do you hear Hubble when she's asking John about who he dropped in the water?
Objection, that's hearsay, Your Honor.
No.
So prior to you transporting him, while he's sitting in the back of the cop car, he demands or requests you guys to get his Bible from the car, right?
So I'm guessing I was told the Bible was removed from the car.
And he's saying something about Michael back there, right?
Yes.
And then you transport him, right?
Correct.
And while you're transporting him in the back of the police car, he's in handcuffs still, right?
Yes.
He's got that cage in front of him, right?
Yes.
And he asked you if you'll just take him to the airport, right?
Yes, he did.
He also asked you to take him to Babylon, correct?
Yes, he did mention something about that, yes.
You didn't put that in your report either, did you?
No, I did not.
And you testified on direct that he said, the only way she will live is with him. What he actually said to you in that car was, the only way he will live is with him, correct?
Yes, I probably read the wrong statement from the depot, yes.
And so John doesn't use the words I or me or her at all, right?
No.
He says the only way he will live is with him, correct?
Correct.
You didn't include that in your report either.
No, and in my depot it even stated that I was supposed to do a follow-up, and I forgot to do the follow-up with that, yes.
You agree that during the entire time you were with John, he was emotionless?
Except for the couple of times that he was fake crying, yes.
Okay. And the fake crying you also didn't put in your report, right?
No.
You thought that his demeanor was off for somebody who had just lost a child, right?
Objection,
Yes.
it's his opinion, Your Honor.
Right?
Yes.
He was just too calm, correct?
I felt so, yes.
When you have him down at Manatee, at some point you're asked to help take John to the restroom, right?
Yes, I did.
How far is the restroom from the interrogation room?
A couple rooms away. I have no idea.
Okay.
I
So
don't recall that. I don't recall that building. I just know we went through a couple doors and then to the restroom.
okay. Fair to say though, on the video from at no point was the video stopped. The recording didn't stop with the video, right?
I have no idea. I don't know how their establishment works. I'm saying probably not.
So you would be comfortable in us judging the time he was gone from when he exited the room to when you guys walked back in the room?
Yes.
Okay. And when you guys got to the bathroom, John indicated he couldn't pee, right?
I don't recall. Honestly, I don't know if he actually urinated or not.
Okay.
From my understanding, I thought he did, but he may not have been able to.
May I have one moment, Judge? All right, officer. So after John is taken from the interrogation room, you then transport him back to St. Pete, right?
Yes, I did.
And at that time, he says to you that you don't know what I've been going through, correct?
No.
He didn't say that to you?
No, not then.
When?
He said it from when I was transporting him from St. Pete to the Pinellas County Jail. As I testified earlier, I stated that he made those 3 statements.
I'm
on
sorry,
the
so
way.
you're in Pinellas County, though. I'm sorry, from the St. Pete jail, not Manatee, from St. Pete jail to, or from St. Pete Police Department to Pinellas County Jail.
Correct.
He tells you, you just don't know what I've been going through, right?
Yes.
And he also asks you what he did wrong, correct?
If I refer to my report, I'll tell you exactly what he stated.
Sure. The suspect wanted to know what he did wrong?
Yes.
Nothing further.
Let me read the record.
Briefly, Your Honor, yes. So I want to go back to those statements. He didn't just say that he didn't know what he did wrong by itself. He had other statements that he made at the same time, correct?
Correct.
So I want you to walk me through those again in order. When you're going from the St. Petersburg Police Department to the Pinellas County Jail, what's the first thing that he says?
The
And
first-
you can refer to your report and give us the answer.
The first statement he said, in reading the report, he stated that he spontaneously stated that he did not throw his daughter into the water, but dropped her into the water. Well, that was his first statement, and then right after that, he stated that you do not know what I've been going through, was the second one, and then the last one is this the statement with the he was asking wanted to know what he did wrong.
And that was after he made the previous 2 statements, that he
Correct.
made that third statement. Am I right? That's all I have.
Anything further?
Officer, I just want to clarify something. You just broke down those statements you said as the first, the second, and the last, right?
Yes.
Those were all after whatever he said about Michael, correct?
Yes.
When he told you to take him to Babylon, correct?
Objection.
What's the objection?
Asked and answered.
Hold.
Those 3 statements, the ones that you identified as the first, second, and last, those were all after he had said something about whatever he said about Michael at the scene that you didn't notate, correct?
Right.
When he asked you to take him to Babylon, correct?
Correct.
When he asked you to take him to the airport, correct?
Correct.
And when he told you the only way he will live is with him, correct?
Yes.
Nothing further.
Anything further?
There you go.
Okay. Anybody have questions for Officer Carter? No? Excused or standby?
Stand by.
So Officer Carter, thank you for your testimony. You're on standby.
Thank you.
State you may call your next witness.
Your Honor, at this time, the State of Florida rests.
Counsel approach, please. These pads on the chairs. Thank you.
All right, folks.
No problem, take that all back.
hearing report, Your Honor.
Anything we need to address?
No.
No.
It's 11:55, Your Honor.
Yes.
All rise. Court being recessed. 11:55, according to the courtroom clock.